My name is Jonathan Bench. I am an international corporate and transaction attorney with Harris Bricken based in Salt Lake City, Utah. I've been practicing for about 12 years now, a mixture of the East Coast and West Coast practices. And so it's been very interesting working with Harris Bricken the last 4 years as primarily doing international business transactions. I work with a lot of US companies that are going outbound, often to China, or they're trying to solve the China problem. That'll be another webinar I'm sure that we'll do in the future, is solving for China and what's happening now and what it will look like in the next 5 to 10 years. And then the other side of my practice is working with international companies that are coming to the United States for the first time, that are trying to set up operations in various ways. And so I'll give you some different examples during my presentation about the types of companies that I'm used to working with. Akshat, why don't you go ahead and introduce yourself, please?
Hi, everybody. I'm Akshat Divatia. I have been at Harris Bricken since 2017. I do corporate immigration primarily, and there's a smaller part of my practice, which is also family immigration. But this is all typically inbound immigration. I represent companies in all stages with respect to attracting and retaining talent, individuals to employ in the United States. And the family immigration side of my practice is to help individuals, sponsors, spouses, fiancés, parents, to get folks naturalized permanent residents, both in the terms of employment and family-based context. So that's what keeps me busy. I enjoy working with Jonathan because we have a similar set of clients, and we want to be able to provide that comprehensive solution to clients, both from the beginning to the end. And the purpose of this webinar is essentially to allow you to see both sides of that particular spectrum. I have also been a paralegal prior to going to law school, so I've been in the immigration field for more than 25 years now, and I am looking forward to sharing my insights.
Thanks, Akshat. So I'm going to start out by talking about the U.S. as a market altogether. So we put this webinar together as a way to talk to primarily international companies coming to the U.S. or looking to come to the U.S. for the first time or second time, or something's changing with the way their U.S. operations are set up. So I'll talk about the U.S. market generally, then about investment in the U.S. Along with some other tidbits like employment-related issues if I have time. We're cognizant about splitting the time fairly evenly, so I may go through some of my slides quicker than others. And then Akshat will be talking about immigration overview, different types of business and visitor visas, certain circumstances with specialty workers, intercompany transferees, and then treaty investors and entrepreneurs. So, and we will end with Q&A, but we are happy to take questions along the way. We'll keep an eye on the chat panel, and if there's something that comes up that is going to be relevant to either of us, I don't mind being interrupted personally. So Akshat, if you see anything that comes through, feel free to interrupt me because we want this to be helpful, and for those of you that have taken the time to tune in today. So the U.S. market generally, when I am talking to foreign companies, and to give you some examples of the types of companies that I work with, I have actually a growing blockchain practice. So my work is split between product-facing companies in terms of tangible products, and then software type companies. So I have some software company in the UK, another blockchain software company based in Canada with international executives. I have some Southeast Asian seafood companies that I represent that wholesale into the United States, and then a range of funds, investment funds that do work in the United States as well. So the first questions that I get, and also actually some Indian companies as well, and this is what I'm thinking of because most recently I had a conversation with one of our Indian clients that is setting up in the U.S. for the first time, and usually the first question I get is, which U.S. state do we go to? It's mystifying the way that the U.S. has a federal and a state government system where the states have a large amount of autonomy with a federal overlay. So typically the people ask me, they always ask me about Delaware, If they're tech focused, they ask me about Wyoming as well, or Nevada. And so those are the top three. And then I mentioned Utah here because Utah is my home state now, and Utah has some, it actually has some special accolades that I'll talk about in the next slide. Typically, the bigger population states, which I have marked here, the New York, Illinois, Florida, Texas, California. I have another slide to talk about the pros of those. So typically, when I'm talking to clients, there is not an investment focus or not an immigration focus initially. That may come up in the conversation, and I will ask them about it, but typically I want to understand the U.S. operations, specifically if they have partners in particular states, if they have employees in particular states, if they have, where their potential market is for their customers, their customer base. So those are all important questions. The U.S. is a big country, and so logistics can be very important, especially if we're dealing with physical goods. So in terms of popular reasons, Delaware is always popular for companies that have big aspirations. I say that because if companies are coming to the US because they want to raise capital or they want to go public at some point, then typically Delaware signals to investors and to other business partners that the international companies understand the way the US market is established. They know that Delaware has a strong body of corporate law that gives certainty to directors and officers and investors. And so, and it also has a quick and sophisticated judiciary and legislature, which means that laws can be passed to address certain issues, let's say high-tech changes in finance or other areas. Delaware can respond very quickly. The judiciary also is very quick, and there are specialty courts. So Delaware has set itself up for many, many decades now to be the preeminent jurisdiction in the United States for companies that I think have big aspirations, and that's how I describe it. So if for companies that see the U.S. as an opportunity and also want to grow, Delaware is almost always in the conversation, if not the state of choice. And it is possible to set up in Delaware and have actual operations anywhere else in the United States. So just because you set up as a Delaware C Corp or a Delaware LLC doesn't mean that you have to have boots on the ground in Delaware. Wyoming is typically popular when we're talking about lack of state income tax. It's very pro-business. Similar to Delaware, it is trying to position itself as an upstart to Delaware. Nevada is similar as well. It's close to California, closest to California, while being what I consider quite a pro-business state. Utah is not that much farther inland from Nevada. Also has low taxes, very pro-business, and recent accolades, which I'm going to share with you in the next slide. The larger states matter in terms of population size. So if you're the type of company that is going to rely on an immigrant community as a base because you have the language or cultural affinity, then it makes sense to look at the more populous states in the United States and try to set up a base of operations there. They tend to have large markets, available employees, and all of these are close to shipping ports, if that matters. So just in terms of Utah accolades, I have to share this because I'm in Utah, and it's quite impressive for a state that's only just over 3 million in population. Just in the first 6 months of this year, Utah has the best performing cities, best economic outlook for the 16th year in a row, best cities for starting small business, best state, best economy for the U.S. News and World Report, and that's based on the diversity of the economy, really, because we're not just based on one industry. We have high tech, we have defense, we have services, we have export. We're a very export-focused state. Financial literacy is big. We have the largest number of banks based in Salt Lake City, Utah, outside of New York City, and then the best state to start a business. So a lot of small and medium-sized companies in Utah and very outward international facing, which is one reason why I love practicing here. Now, if we're looking at languages, for companies where it's important to tap into local languages, population centers, plus large communities, I won't go over every state here, but these are the 5 most populous states in the United States, with California being at the top, Florida and New York. Texas is next. So California, Texas, then Florida, New York, and Illinois. So these are large. As I said, Utah, where I live, is just 3 million people. So if you're If you have purposes, if you have reasons to set up in a place where you need large populations, then these are often the first states where you will want to look. In terms of U.S. entity selection, because after we have the discussion about which states are most appropriate, then we talk about the type of entity. And this is often driven by taxation. You'll see here that in the United States, every entity that you will use, typically we're looking at between a C corporation or an LLC, you have limited liability as a parent company coming from abroad, or as an individual investor coming from abroad. So limited liability is really not an issue. The only time that you won't have limited liability and it will be tied back to your parent company is if you decide to just directly do business in the US by registering your foreign entity in the United States to do business. And companies do that, but typically they want a liability shield between their parent company at home and the US operations for a variety of reasons. In the US, we have no minimum investment capital requirement. You can set up a company for a few $100s and be up and running, and there are no requirements, no significant government registration. So it's very easy to do business in the US. Foreign ownership is permitted. We have no issues there. Income tax is, of course, important. We have tax treaties with well over 100 nations. And so typically you will not end up paying double tax, except in the situation of a US C corporation, which is most companies see that as a necessary evil because it keeps the US tax liabilities away from the parent company back home. And then, of course, in order to pay taxes, each entity needs a tax ID number no matter what. So in case you're wondering, the green is good, and check is required, and the X is not required. And we're happy to share these slides later to the extent that anyone wants to view them. Business incentives, I get a lot. I was in New York City just 2 weeks ago, meeting with a lot of international lawyers, international business lawyers, mostly from Europe. And as you know, we're in the age of government incentivized business, which is kind of undoing the globalization of the world, but it is where we're headed and where we've been headed. And so typically governments are involved, and more so than in the past, the US government is very involved at a federal level. States have always kind of vied for supremacy. Sometimes it's a race to the bottom to try and attract businesses, or for, in the instance of Delaware and Wyoming, they are trying to vie for business activity to be seen as the state, the go-to state for a certain type of industry. And so when we're looking at the business climates in the US and incentives to come, incentives to set up in different states, you're gonna need to do an analysis based on the industry you're in. If you're high tech, whether there's certain investment thresholds for the state to really start to woo you in terms of tax breaks, duty fees, any kind of waiver of land use fees or permits. And typically, like I think in most countries, most international countries, every state in the US is focused on rural development. So to the extent that you can bring jobs, factories, operations to more rural areas than urban areas, you will get the interest of the state. You will get their attention more readily than if you're just going to a large population center. And there are tax breaks. So there are conversations that you need to have. Once you decide where you want to set up, the type of business entity you want, then you want to start having conversations with local officials to understand what kinds of tax breaks and other incentives are available. Moving on, the US, if you've been paying attention, the US has some recent legislation just passed at the end of 2022 that have been focused in two major areas. One is the clean energy funding, and there is a lot. I mean, that's billions and billions of dollars available for companies that are engaged in clean energy funding, prescription drugs, and then also in semiconductor manufacturing, R&D, and tax. So if you happen to be in those industries, or you know someone who is, those are going to be the focus until that money is spent, and it will take quite a few years. The lead time for semiconductor manufacturing is very long. So there will be at least a decade before this money is spent, I've got to think. So keep those in mind. In terms of investment in the US, the next part of the analysis is how do you plan to be in the United States? Do you plan to self-fund? Do you plan to find joint venture partners? Or do you plan to raise capital from either private markets or public markets? And so the US takes this very seriously. US has tried very hard to be the financial center of the world and to continue to be the financial center of the world. So we have very robust laws to protect investors, to keep the market integrity strong, and we see this whether companies are trying to raise capital from private investors or from public markets. So there are a lot of pitfalls if you intend to come to the U.S. and start raising capital. That is another separate discussion to have with a U.S. attorney who really understands how to raise capital in the U.S. Because there are severe penalties for doing that incorrectly. Another thing that another part of the conversation that I have with international companies is if they want to acquire a company. The U.S.'s Committee on Foreign Investment in the U.S., we call this CFIUS, had increased jurisdiction and an increased mandate over 2018, or from 2018 onward under the Trump administration. This was largely focused on Chinese investment in the U.S., and it is one of the few bipartisan issues in the United States that both sides of the political spectrum are very focused on. So CFIUS basically looks at CFIUS has jurisdiction over any investments in U.S. companies. And it doesn't matter whether it's a controlling interest or a non-controlling interest, even if it's just decision-making power or real estate. So any of those parameters. So unless you're doing a greenfields investment in the U.S., if you are engaging with a U.S. company in any way as a joint venture partner, as a financing partner, which is typically how companies like to enter the market, is to find a good partner and do some kind of joint venture together initially. So we need to at least do a CFIUS analysis and see whether the transaction needs to be disclosed. The industries, so other than those kind of broad operational perspectives, there are certain industries that matter more to CFIUS than others. If you happen to be in a critical technology, so wireless communications, if you're in semiconductors, if you're dealing with critical infrastructure, any type of communications infrastructure in the US, or if you're dealing with sensitive personal data. So I always remember this as the TID, the technology, infrastructure, and data is what CFIUS is interested in. So it's not every transaction, but if you happen to be in these types of industries, then you need to pay attention to that as well. The declaration itself, dealing with CFIUS, is not necessarily cumbersome. I think those of you that are coming from outside the United States will feel like this is not a really high burden, although most companies want to move and close as quickly as possible. So I think that in terms of timelines, the shortest timeline is this will stretch your closing out about 30 days from the time that everything's submitted to CFIUS. And they're very responsive. They're drilling down into your parent entity all the way to the beneficial owners. So it's better to disclose if you're in the type of transaction that needs to be disclosed. I've been through this with a client just in the last couple of years. It was not overly painful, but it did need to happen. And there are only 4 safe harbor countries. Those are Canada, UK, Australia, New Zealand, with New Zealand being added just in 2022. So not a lot of safe harbor countries, which means that you even for countries that we consider very strong political allies to the United States, we still need to do a CFIUS analysis. Another thing to keep in mind, in 2022, as part of the Consolidated Appropriations Act, or the follow-on, there was money allocated for the Department of Treasury, which is the executive organization that runs CFIUS, to look at U.S. outbound investment restrictions. I know that a lot of companies that are coming from abroad would often love to have U.S. investment dollars flow the other way, especially if you're engaged in a joint venture. And so we don't have U.S. outbound investment restrictions yet, but we expect to have some guidance sometime this year. So that's something else to pay attention to if you have capital that's going to flow out of the U.S. back to your home country. And I think for that, I guess this is my last slide, Akshat. I'll just touch briefly on U.S. employment issues because it's a good segue between what we're doing together. And it's also important for non-U.S. companies to understand that the U.S., this is one of the areas where the U.S. is can be very messy. often because we have pro-labor states, we have pro-employer states, and they're right next to each other, and you won't necessarily know where they are or why why you might have collective labor issues in one state versus another state. So if you remember back to the map that I showed earlier, typically the states with the largest population centers are those that tend to be pro-labor, and those that have a less population tend to be pro-employer states. So it's a specific type of chess that you need to play to figure out exactly where to put your operations, where to put your employees, and understanding how to treat U.S. employees, and also what their expectations are in terms of written employment contracts, employee benefits. The tech community, you'd have employees who would be expecting some kind of stock options or restricted stock units. So it's important to understand, along with all of those dynamics, exactly what kind of state you're in and how they treat the employer-employee relationship. So with that, I'm going to kick it over to Akshat. And I know I have to give the controls here, Akshat. Just give me 1 second. Coming your way.
Yeah, to add to what you said, even in the concept of at-will employment, it's really interesting because in Europe and in other jurisdictions, this notion of long-term contract or yearly contract doesn't exist here. So for a company moving into the U.S., the notion of at-will employment throws them off. What do you mean? I can sponsor somebody, but if that person can leave with a 2-week notice, how is that helpful? So anyway, giving it a little bit of my presentation, I will I'll go into that as we go along. So excuse me. So thanks very much for that comprehensive overview of the business considerations that companies need to have when entering or expanding in the U.S. market. We're going to shift gears a little bit, and we're going to talk about what happens once a company is established and it wants to hire individuals in the U.S. or transfer individuals from outside the U.S. from their qualifying entities overseas. The immigration landscape, it's important to recognize that, there are a lot of non-immigrant and immigrant visa options, and they're all typically, especially the non-immigrant ones, there's an alphabet soup of visas going from, the B1 visa, B1, B2 visa is the most common, that's the visitor visa. And we'll talk about some of them in my presentation, but generally you can think of them as being in 2 different buckets. There's the family bucket, and then there is the business bucket. The family includes, visas for fiancés, and these are both non-immigrant and immigrant visas, but visas for fiancés, for immediate relatives, for victims of trafficking and crime. And there's also something called diversity visa, reserved for individuals from those countries that do not have a history of high immigration to the US. So in order to kind of level out the playing field, the countries that do have a lot of immigration into the US, as you may know, are China, India, and Mexico and Philippines historically. But the diversity visas are for countries except for those. The focus today, given the fact that we're talking about corporate issues and issues facing businesses in the US, we're going to focus on the business bucket of things, in particular employment, investment, and also some options for those who are here in F1 in student status. So who are the actors and what roles do they play? In US immigration, you have 2 main departments. You have the Department of Homeland Security and you have the Department of State. I'll start with Department of State, which is on the right. The Department of State essentially has embassies and consulates around the world. That is typically where most people start their journey for immigration into the US, where they apply for a particular visa. They have an interview. Sometimes interviews are waived. And then with that visa in the passport, the stamp in the passport, the individual travels to the US. And at that point, the Department of Homeland Security comes into play. So you have the first point of contact is the Customs and Border Protection. These are the gatekeepers in US immigration. They can determine whether a person is admissible in the US, whether a person is allowed on a particular visa and for the duration of time of that visa. So CBP has a lot of discretion. There isn't a way to typically appeal a decision by the CBP, nor is there a decision necessarily to appeal a visa denial by the State Department, by a consulate overseas. So assuming that the visa is issued and the individual enters the U.S. In the status that they are looking to enter, once in the U.S. typically is where they will encounter U.S. Citizenship and Immigration Services. This is the main adjudication agency where applications and petitions are submitted, and decisions are made about extending a person's stay in the U.S. or changing their stay from one category to another. Now, where there are violations of that stay, if somebody has worked without authorization or has overstayed their visa, then the Immigration and Customs Enforcement, ICE, comes into play. They are in charge of initiating removal proceedings to deport individuals from the U.S. And so, the three agencies, they have an important role, and they feed off of each other, as does the State Department. The last one there is Transportation Security Administration. That those are folks that are responsible for making sure that there's safety across our airports and seaports. So the first question that I often get from my clients overseas is, we have identified a particular person. We want him or her to go to the U.S. to open our operations, to open our company, to expand our operations, to see what the market is like, to get customers. And why can they not come in on a visitor visa? The visitor visa is typically very easy to obtain, relatively speaking, in the sense that if an individual has ties to the home country, is employed by a foreign employer, then the individual just needs to demonstrate the purpose of the visit, and usually the consulate will issue the visa, sometimes with an interview, sometimes without an interview. For some countries, especially Western European countries, Australia, Japan, there's something called the visa waiver. It's the ESTA, the ESTA, that's the electronic system for travel authorization. Individuals who will qualify for that based on their nationality do not need to go to a consulate to apply for a visa. They can apply online and they will get permission to enter the US, and with that they can just board a plane and come to the port of entry to explain their basis for entering the US. These rules are there, but the best way to illustrate them is through this old 1966 case, which is still good law because it's often cited by immigration agencies about what constitutes acceptable B1, B2 activities. B2 is for pleasure, B1 is for business. When a person applies for visitor status, the visa typically is both B1/B2. And the determination of whether the person's stay in the US is on a B1 or on a B2 depends on what the CBP officer decides at that point in time. So if a person is coming in for a conference, it has a B1, B2 visa, then the entry will typically be in B1 status. If the purpose of the entry is to visit Disney World, then the entry will be typically in B2 status. But this case law that I'm talking about, it's called Matter of Hira, a 1966 Board of Immigration Appeals case, where the individual in question was a national of India, but residing in Hong Kong. He was working for a company that manufactured bespoke suits, customized suits. The company would send brochures to potential customers in the US. When the customer would show an interest, the company would indicate that a tailor would be in the United States to take measurements. The tailor would come, and Mr. Hira was the name of this tailor. He would typically meet his customers at a hotel. And in this case, Mr. Hira came, he wanted to extend his time in the US. He asked for an extension, but in the process, the US government started deportation proceedings against him, alleging that he was violating the terms of his visitor status. Ultimately, the Board of Immigration Appeals decided that Mr. Hira was not violating status because he was not working in the United States. The work that he was doing was in furtherance of the company in Hong Kong. He was here while he was on the payroll of the Hong Kong company. He had a definitive plan for departure from the US. He didn't have immediate family here. He was there for the purpose of taking measurements, sending those measurements over to the company. The company would make the suits, and the customers would pay the company directly in Hong Kong. So the activities in the US were quite marginal. They were not supplanting, they were not taking away jobs from American workers. So when you look at this criteria, it's a specific short-term visit, no compensation from a US source, the residence and employment outside the US, it shows that B2 visits, B1 visits in particular, are good for, limited activities. They're not for productive work in the United States. Where it's also important to notice that an investor who's looking to invest in the United States can come in as a B1 to determine the scope of, the prospects of business in the United States. So finding office space, finding talented individuals who the company may want to hire, signing a lease, things of that type, but nothing beyond that. So I'm going to switch over now. We're going to talk about certain scenarios. Given the number of people who have joined and who registered, we have a mix of people from different spheres. And so the first scenario deals with those of you who are in the human resource realm. And I'm going to use, essentially a scenario here, fictitious company, Lightyear Labs. These are all based on actual clients that we have. Lightyear Labs is a US-based tech firm, wants to expand its tech pool. The company wants to aggressively scale its operations and headcount in the US. They have identified several candidates, and a few of those are outside the US. And the new HR manager, Adriana, is unfamiliar with international hiring. And in this scenario, what would she propose to the hiring managers about the visa options for these qualified candidates who are outside the US? And some of them might be even in the US, but foreign nationals in other status. So the most common option for individuals, for companies in the US to hire individuals is the H-1B. It's a specialty occupation visa. And what that means is that it is a visa that requires the occupation. It's a visa reserved for those occupations that require a bachelor's degree. Let me say that again. It's a visa that is reserved for individuals in those occupations where the occupations themselves require a bachelor's degree. So you have somebody who has a master's in computer science from Greece, but wants to come to the US and work as a cashier in a grocery store, despite the fact that this individual possesses a master's degree, because the job itself does not require a minimum of a bachelor's degree, the job of a cashier, the individual would not be eligible for an H-1B visa. So, in our scenario, Lightyear seems to be looking at individuals who are qualified, who have at least a bachelor's degree. So H-1B is a viable option. Of course, one thing to keep in mind is that the demand for that visa is significantly high compared to the available number of visas. There are 85,000 visas, new H-1B visas that are available every year, of which 20,000 are reserved for individuals who hold US advanced degrees. So an individual who obtained at least a master's degree from a US institution. The remainder of the 65,000 visas are for individuals who have overseas degrees and no advanced US degrees. And because the demand is typically, 3, 4, and in some cases, in the most recent lottery that was run this year in March, about a 10% chance of being selected, it requires a lot of planning ahead of time. So the window for registration of H-1Bs opens in March of every year. It closes typically in 2 to 3 weeks' time. In all companies that want to register individuals must do so within that particular time frame. And then the government will run a lottery, and depending on whether that registration is selected, the employer would then be invited to apply to file a petition on behalf of that employee for employment not earlier than, meaning the earliest employment in H-1B could happen on October 1 when the government's new fiscal year begins. So March window opens, let's say in June, the company gets notified, or July, the company gets notified. They will prepare the petition, submit the petition, and then the individual will be able to apply for a visa stamp at the US consular post and come to the US for employment starting October 1 of that year, October 1st of that year. We can, of course, go into an hour-long webinar on just H-1B visas themselves, but right now, the focus of this, as far as big picture options, H-1B requires planning, but that's something that the company could undertake and should undertake to make sure that its candidates are registered in the lottery so that they have a chance of being selected.
Akshat, can I ask you a really dumb question? Is this lottery really a lottery? There's no way to game that? You just make the qualifications and some random selection. I mean, is it really totally anonymized lottery?
Well, it's funny that you asked that, because this particular year, the selection rate dropped down to less than 10%, and it was revealed, and their investigation is still going on. The findings have not yet been disclosed, but there were multiple registrations filed by affiliated companies, or not just affiliated companies, but companies that basically allegedly colluded to register the same individual, and then so that individual would have multiple registrations, not by the same company, but by a series of companies, thereby increasing their potential of being selected. Once selected, the argument is that at that point, the company that is lucky in the registration would then file the petition and then end up transferring the I think we're getting an alarm over here, but okay, we just had a fire alarm in the building, but it looks like it's a test, so I'll continue. So it turns out that the number of registrations was significantly high this year compared to previous years. Typically, there's a 1 in 3 chance, and there is a way that the government has can find duplicate registrations. But what happened this year was that these were not truly duplicate registrations. These were registrations by seemingly unrelated companies, with the notion that once selected, they will be the individual could be transferred to the company that really wanted to employ that individual after October 1st. Okay, so that's a segue, but it's an excellent question. Let me jump over, in the interest of time, to some of these really highly qualified candidates that Adriana has resumes for, and those individuals may qualify for the O1 Extraordinary Ability Visa. Now, this is extraordinary ability vis-a-vis the peers in that particular occupation. So not vis-a-vis you and me and anybody else in the general population, but in that particular sphere, in those among those particular occupation. It requires a showing of sustained national or international recognition, and that has to be evidenced. It has to be proven through participation on panels, judging the work of others, publications, awards that were won, membership in organizations that are competitive to get into, things of that type. So the O1 is possible for individuals who have reached a fairly high level within their own occupation, and they command a high income and are able to show that they stand out in the crowd. And there's no lottery for O1 visas. They can be applied at any time. One thing to note, however, that the O1 is not an immigrant. There isn't a pathway. It's not a dual intent visa. There isn't a pathway for O1s to get immigration, get permanent residence. So they have to be converted at some point in time, to a visa that allows for that dual intent, both the non-immigrant intent and the immigrant intent. Okay, let's switch sides now, and let's talk about a German company that is specializing in environmentally friendly packaging solutions. They wish to tap into their growing US market for sustainable products. Bruno, the founder and CEO, wants to lead its US expansion. He has a close friend in California who wants to invest in the business, and Bruno is not sure if he wants to do this individually as an investor, or does he want this done through Green Earth, setting up a subsidiary in the US. So The first option, though, the option that we deal with on a regular basis is that of the L1 intracompany transfer. This is for companies that are qualifying entities. In other words, there has to be a parent subsidiary relationship where the US company could be either the parent or the subsidiary, or the companies can be affiliates, meaning they can be owned by the same company, holding company, for example, or by the same investors who have to have the same percentage, essentially, in both companies. So if you have 4 investors in the German company, each holding a 25% share, the U.S. company also has to reflect that share. It cannot be it cannot be at a different percentage. Let's see. So the other requirement for the L1 is that the individual seeking to be transferred has to be employed for at least 1 full year within the last 3 years for the overseas entity. And any time spent by that individual in the United States as a visitor on ESTA or a B1 does not count towards fulfilling that requirement. So you can't have somebody who spent 6 months here, has held a position for a total of 1 year overseas. For immigration L1 purposes, it still counts as just 6 months. The individual will need to go back, complete the 1 full year of experience, and then we can file a petition. One thing to note here is that the US company must be doing business in the US, whereby the individual, the company rather, cannot just exist on paper. It has to have physical presence. It has to be doing business by having contracts, by having service providers, web presence, customers, fulfilling its corporate responsibilities, as well as showing that it's generating an income that can sustain an executive or a manager coming in from overseas to help grow the business. If, for example, Green Earth decides that it doesn't want to commit to having a subsidiary in the US, Bruno would still be eligible for an investor visa based on his own personal funds. So he can invest at least 50% in the in establishing the new company, and his friend in California can put in the other 50%. But Bruno needs to play a leading role, an active role in the enterprise. He cannot just invest passively and get the visa. He has to be the one to manage the company's operations. The friend from California can put in the money, but essentially be a silent partner or have a some other type of a secondary role. The E2 option is really good for individuals who with whom the U.S. has treaties of friendship, commerce, and negotiation. I'm blanking out on the end, but navigation, yes. Friendship, commerce, and navigation treaties. And so not every country has that. Typically, China, India, they do not have those treaties with the US. But the good thing to note is that an individual from one of those countries, if he or she ends up getting the nationality of another country, such as Canada, for example, then that individual becomes eligible again to apply for an E2. And we do this a lot with Indian and Chinese nationals who immigrated to Canada, who have Canadian citizenship, and at that point in time, they can become eligible for E2 visa to come to the US and work in E2 status. The other great thing about the E2 is that it is renewable indefinitely. There's no cap to the number of years, as long as the individual continues to hold the nationality of the treaty country, and as long as the company continues to grow, creates jobs, remains profitable. We have clients who have been, in E2 status for more than 2 decades, actually. So it works for individuals, in select circumstances. Let's go on to the last scenario, and I want to leave open some time for questions as well. The last scenario is that of Kathy, who is a student in F1 status. She holds a degree, bachelor's degree from China, and an MBA in management science from a top US university. Management science is one of the STEM fields for science, technology, engineering, and mathematics. And that qualifies her for not just 12 months of optional practical training, but an additional 24 months of STEM OPT, optional practical training. As part of her capstone project, she's developed a financial analytics tool that she wants to transform into a fintech startup. She's been working on that initially as part of her OPT, but you know, and self-employment is permitted in OPT status, as well as in you know, in the STEM OPT context, it's also permitted. But then once she exhausts her 36 months, 3 years of training, what are her options after that? So this is a relatively new rule. It's new in the sense that even though it was, you know, introduced by the Obama administration before 2017, its you know, its application was not very clear. There was no guidance on it, and now under the Biden administration again, there has been a renewed energy to use this rule to advertise it and to get individuals to apply. What this rule provides, and this is very important for those individuals who are in F1 OPT status, who have maybe registered for the H-1B lottery but have not been selected, given the very low selection rate. The IER allows for the parole. It's not a permanent status, but it allows for an initial 2.5-year period for the entrepreneur to remain in the US, to grow the business, to attract investment, and that investment can be either private or government investment, but it cannot include the entrepreneur's personal funds or funds from, you know, relatives. And so initial parole is on the basis of the amounts that you see there, 264,147, at least those amounts, where the entrepreneur has to play a central and active role in the entity and must have a substantial ownership interest in that company. The idea being that you are, you know, Kathy has this great idea. She has a business plan. She's able to get investors to come and contribute to her potential, and that will allow her to stay in the US for 2.5 years. At the conclusion of that time, prior to its conclusion, Kathy would need to request a second and final, up until now, this is just a total of 5 years, another 2.5 years to extend her status. And there she would need to show that the actual amount of investment was higher, has been higher, $528,293 at the very least, or that she has created, the company has created at least 5 qualifying jobs. You know, this is, as I said, this is relatively new, and you know, we're seeing that not as many people are applying for this, but that's also because it's not really advertised. So it's important for people to know that this exists. The one thing to keep in mind here is that the spouses and children of entrepreneurs will not qualify for IER, for this parole automatically. They would each need to individually apply, which is actually a little, you know, disconcerting. But oftentimes, I guess the premise behind the rule is for, you know, essentially younger individuals who have bright ideas, who don't have families, and who want to focus their energies on the business itself. Let's look at some of the other options that Kathy has, and this is kind of a recap of what I described earlier. The O1 extraordinary ability, it requires the proof of extraordinary ability. You know, Kathy, given that she has advanced degrees and a real potential for growth in the US, if her idea is truly attracting investors, then she might qualify for the O1. Or the individual or Kathy can, you know, have the company sponsor her in H-1B status. And I'm going to toss it over to Jonathan here, because we did get a question about, you know, can you be self-employed in H-1B status? And so the issue of employer-employee relationship comes up, and what Jonathan and I, we routinely, when we talk to people about this, the question here is about, you know, what kind of business structure can you create to allow for a non-citizen to be an employee of a company that he or she has founded? So Jonathan, I will hand it over back to you, if you can talk about that.
Yeah, so the key with this analysis is how much control the company. Typically, if you have, and this is the reality for a lot of founder companies, you have one founder they want to keep maximum control of everything. But that doesn't work in the immigration context because we have to have the separation between the entity itself and the non-US person who is trying to get the visa. So it seems a little counterintuitive for an entrepreneur that is putting money in, putting time in, has the ideas. But the company really has to be stood up as independent from the individual, to the extent that they don't have board control, they don't have ultimate. They basically they can't undo it. They have to release a certain amount of control, and we can do that in a variety of ways in the U.S. Typically, especially in states like Delaware, but basically every state in the U.S. you have freedom of contract. And so if we typically would have to do some what I consider strange and slightly unorthodox ways of setting up the company, which is to create a strong firewall between, by propping up a board or a board of directors or board of managers that really does have ultimate authority over the employment status, over the compensation, so that we have a strong firewall, as if the individual seeking the treaty or seeking the visa is not in ultimate control of everything. Because typically, even if someone props up a board, they can, as the sole or primary shareholder, they can replace the board at any time. So they functionally can undo it at any time. And of course, U.S. immigration knows this, and so it's going to be a facts and circumstances analysis to make sure that they have actually relinquished significant control of their own company, which is a kind of a hard position to be in. I'm sure you have additional thoughts on that, Akshat.
No, I think you described that well. The key is to make sure that those corporate documentation is very clear from the get-go, and that the foreign national doesn't have fingerprints in actively being involved in the decisions that are made by the board, or in this particular, in the case of an LLC, by a manager. So you have manager manage, member manage, and the foreign national should be a member but not a manager. And where we do have that bifurcation very clearly, we explain that in the support letter and the other documentation evidence that we supply to the U.S. government in our petitions, and these cases get approved because they have been structured well from the get-go, precisely being aware of this employer-employee relationship, the right to control context, and cases get approved. So it's really important to join forces, to have both the immigration angle and the corporate angle covered in those early consultations. We like to do these consultations jointly, similar to this particular webinar. Jonathan will take the first half hour, I'll take the next half hour, and we provide a lot of information to prospective clients, just so that our goal is to educate. And that's also the reason why we do these webinars, because we want people to have understood that these considerations are real and they can impact. As I say, we can do emergency room surgery, but we love actually counseling as primary care physicians the clients when they come in, before they come in, just so that they know that we want them set up for success, so they don't have to be rushed to the emergency room to undo something that could have been structured better from the onset. So yeah, so that is.
I was just thinking, Akshat. Sorry,
yeah.
I'm talking to you. Go ahead. Sorry.
No, I was just going to say that was my last slide, and so yeah, why don't you go ahead and tell me what
we have just a few minutes left, and we'll keep an eye on the panel. So if you have any questions, feel free to drop in. I was just thinking about one of the earliest cases that we worked together on, Akshat, of parent company with a U.S. subsidiary that had chosen a U.S. manager, and the operations just weren't going well. And so the parent company, one of the key owners of the parent company in Europe, decided we need to send. Well, he wanted to send his son to the U.S. to clean up. Right? He said we need someone there immediately. We have issues with banking. We don't have reporting. It's making issues with our tax reporting back home. And they wanted to send him right away. And I remember you put the brakes on that very fast. You said, "This is you will forever put a mark on his any immigration prospects if you send him over on in the wrong status, the wrong visa. So maybe you want to give a little more gloss, just kind of to bring that to light, because for me that was very startling. I'm thinking from the business side, let's fix this operationally. I can do whatever we need to do. We'll fire the U.S. The U.S. manager. We will get control of the U.S. subsidiary again and the bank account. But at the end of the day, you said we have to be a little more circumspect about how we do that.
Yeah, you're absolutely right. I mean, it's in that particular scenario, it happened after the fact. The individual was already in the US when they contacted us, and we said we need to clean up. The individual needs to leave the US. Let's structure this so that it's done right. The entry, going back to one of my first slides about the entry as a B1, B2 visitor, used to be that the notion is, this is a misnomer, but the notion is that, well, if I'm coming in for two things, I can only mention one thing, and that means I'm not lying, but I can do something else while I'm here. So if my purpose of my visit is to visit friends and also to interview with companies, if I just say to the CBP officer that I'm coming in to visit friends, that would be okay. But it's important to note that, in this day and age, the digital records, Customs and Border Protection has access to digital records. They have the ability to perform cursory search on devices. So if they come across your calendar or emails that show that you have meetings set up with companies or for other purposes that you are not actually indicating, then that counts as misrepresentation. Misrepresentation is not just saying something wrong, but it's also withholding material information that, if given to the CBP officer, could result in a refusal of entry. And by choosing to not mention that, you are effectively misrepresenting, and you stand, there's a potential that you could be denied entry and essentially barred from the US for misrepresentation. So it's very important to have these discussions ahead of time. As I say, when it's not so much that we would just say no, it's a question of finding a way that we can be both truthful and creative and informed. You make an informed decision so that you not only preserve your ability to come into the US for that short period of time to discover the lay of the land and to make a bigger decision, but also to not rule out the chance of getting a visa to work in the US once you have made a decision to come to the US. So it's sometimes that small small indiscretion could end up impacting something that would otherwise be a straightforward case for a work visa down the road.
That's great. I think we have 1 minute left, Akshat. So I have, and I didn't see any other questions coming in, but I'm curious now about this searching devices at the border. How does that work in practice? If someone arrives and CBP wants to look, do they say, I want to, open up your computer? Do they have to log in right in front of there and then give them full access while they're sitting? Do they take the computer out of the room, sit there? Or what does that look like?
I think the technology exists that even allows them to perform some kind of a cursory search by putting in a thumb drive. A foreign national, a non-citizen, a non-United States citizen, does not have the ability to say, I refuse to consent to the search and be admitted, meaning they can refuse, but they will not be allowed to come into the US. And a US citizen, for example, is also subject to the same rules in general about the cursory search. However, entry into the US for the US person US citizen cannot be denied. So the US citizen can certainly come to the US, but the CBP has the ability to retain that device and ask the individual to come back later to pick it up. In that meantime, they can perform sophisticated forensics to determine if there's anything that is problematic. But and this is for another webinar altogether. But with more states legalizing cannabis, the entry into the US for the purposes of participating in the cannabis industry is problematic, because at the port of entry, it's federal law that applies, and because cannabis is federally classified as class 1 substance, it cannot individuals, foreign nationals, and green card holders run into problems if they try to come in for those reasons, for the cannabis-related reasons.
Excellent. Thanks, Akshat. Well, we're at time. Appreciate everyone tuning in. We had fun. I think the time went by pretty quickly. And Akshat and I blog and speak quite a bit about these issues, so you can check out our firm's blog. Tune in for another webinar later, and we're always happy to take questions by email or just set up a time to talk with us. We're happy to kick any ideas around with plans that any of you have. Akshat, any parting thoughts?
No, thanks very much for attending. And we look forward to entertaining more questions and holding more of such webinars in the future.
Perfect. Thanks, Akshat.
Thanks.